Hi, my name is Joseph Blocher. I'm a professor of law at Duke Law School, where I'm also the faculty director of the Center for Firearms Law. And I want to talk to you today about the Supreme Court's momentous 2008 decision in District of Columbia versus Heller. Heller is in many ways the foundation of what we think of today as the modern Second Amendment. So in the lead up to Heller, there are really sort of two competing visions about what the Second Amendment is all about. Version 1, we can call the militia-based version, focused on the first clause of the Second Amendment, the part that says the well-regulated militia being necessary to the security of a free state. And focusing on that language, propounded the vision that the Second Amendment is about protecting the organized militia from disarmament. So the underlying theory here is that in 1791, when the Second Amendment was ratified, people were really kind of terrified about this new federal government they'd created, especially the standing federal army. Protecting the state militias was a way to have a counterweight there, right? Sounds anachronistic to us today, but for 2 centuries, this was the vision of the Second Amendment that prevailed in the federal courts. But in Heller, the Supreme Court adopted another vision, which is that the Second Amendment is not limited to the organized militia, but also contains in it a private purposes right. That is the right, an individual right to have guns for things like, for example, self-defense against criminals. This is focused more on the sort of second clause of the Second Amendment, the part that says the right of the people to keep and bear arms shall not be infringed. So when people talk about the core holding of Heller, that's what they mean, that the Second Amendment is not limited to the organized militia, but also it contains within it this right to have guns for private purposes. But Heller does something else really, really important, which is that it recognizes that the right to keep and bear arms, like all constitutional rights, is subject to various forms of regulation, and the court actually lists a few. It talks about, for example, prohibitions on possession by felons, and the mentally ill, dangerous and unusual weapons, or weapons in sensitive places like schools and government buildings. So the major task for Second Amendment law and scholarship since 2008 has been to figure out what kinds of regulations are consistent with the right that Heller recognizes.